Number 22, the people of the state of New York versus Thomas Jackson. Good afternoon, sir.
Good afternoon, Your Honor. I'm Mitch Kessler. May it please the court. I represent Thomas Jackson. I'd like to reserve 2 minutes for rebuttal.
Yes, sir.
Thank you very much.
You're welcome.
I'll start with the first issue raised in the brief, which is whether or not the Sandoval error was harmless.
How was that preserved?
How was it preserved?
Yeah, did you make an objection to the
The
Sandoval?
defense counsel said he objected to any use of that adjudication. And the court,
And then the court ruled, and did he object to the ruling?
counsel didn't say anything at that point, but
Okay, so how is it preserved?
it's
How
preserved.
has the court been put on notice that its final determination on that proffer for the juvenile adjudication about the robbery of the bike? How is the court put on notice that it may have rendered an erroneous ruling and it should reconsider what it did?
Because defense counsel argued before the court made the ruling that it was not a proper subject of impeachment.
Well, defense counsel actually wanted the entire, there are two things at play here, right? One is the fact of the disposition, and the other the underlying facts,
That's correct.
right? And defense counsel objected to everything.
That's correct.
And the prosecutor, I think correctly, consistent with the law, said, I'm not trying to get in the fact of the adjudication, just the underlying facts, right?
That's not exactly what the prosecutor said. The prosecutor said it isn't necessarily proper to allow, she basically had, she said it's not necessarily proper to allow in the fact of the adjudication.
But that it is proper, what you wanted to get in was the facts, that is, he stole a bicycle, essentially.
That's correct.
Right.
But
And
but
the
that's not
judge-
what the proffer
And
said.
then the judge then said, well, here's what I'm going to do, a compromise, and then he did exactly what the law doesn't allow. Is that right?
No,
That is, he said,
what
I'm-
happened was, the people filed a written proffer in which they wanted the adjudication, the underlying facts, and the disposition to be fair game. In the Sandoval hearing, defense counsel argued,
Now, how is that? Their proffer doesn't say that, and it cites the cases that don't allow that. How is that?
their proffer, well, I could,
No, please don't look it up, it's okay.
my recollection is their proffer said the defendant was found guilty of stealing a bicycle, he was adjudicated a juvenile delinquent, and he was placed on 1 year of probation, and they wanted to use that information to impeach his credibility. And in the Sandoval hearing, the defense attorney said, we object to the use of the juvenile delinquency adjudication, the underlying facts. The prosecution made a sort of, they kind of hedged on whether it was outright inadmissible to refer to the adjudication. They said it isn't necessarily proper to use the adjudication.
I guess the point is, once the judge renders a decision on the people's request,
Yeah.
defense counsel did not then object to the ruling. Is that correct?
That's correct, but that's
Okay,
like...
so how is it preserved?
It's preserved because counsel made his position clear before the court's ruling. The court ruled on the ultimate question before it. And I don't think the preservation doctrine requires so formalistic an approach. That's like
Isn't that
saying...
exactly what People v. Cantave and People v. Hamlin require? That
I don't
you
bel-
present this to the judge in time for the judge to cure. And if there's no ruling, what are you presenting? You're objecting to the proffer, but you need a ruling that you're objecting to be corrected.
I don't think that's what this court's precedent requires. I think we're getting back to the old era where you had to take an exception to a court's ruling, which was eliminated when the legislature adopted the current criminal procedure law in 1967. Defense counsel made his position clear, the court ruled.
Well,
That's-
assuming it was preserved, counsel,
I'm sorry?
assuming it was preserved as you're arguing now, there were other, it was error then, assuming arguendo that it was error, and you're saying it's not harmless error.
Right.
why is that?
Well, if you look carefully at the record, you know, the defense was vigorous. The defense was, the first complainant, it was consensual sex, and there were circumstances, there was evidence that tended to support that inference. There was evidence that called into question the credibility of her claim of forcible rape. There was evidence showing a motive to lie because she found out that my client had a girlfriend, and maybe she was jealous, and maybe that prompted her to cry rape.
The first case, the rape was immediately reported to the hotel
That's
desk
correct.
clerk.
And
So
she
that
made
was
a,
before any other information, right?
actually, not necessarily. I don't think the trial testimony really answered which came first. I think there was some evidence, in fact, if you look at the timeline and the telephone records, I think there was some evidence, in fact, that conversation, the revelation that my client had a girlfriend might have occurred before she reported it. And you also have the false statement to 911 operator that she had been at the bar alone that night, not mentioning the
So-
underage friend she brought with her.
So, counsel, under Grant, what you had to establish is whether or not the jury is deprived of any critical information. We assume he would have testified.
Yeah.
So what's the critical information his testimony would have provided? Because
That it was consensual.
you've highlighted everything that's already out there at the trial. So
That-
what is the critical information that the jury was deprived of by not having him testify?
That it was consensual. That's,
Both?
no,
both incidents?
the first one.
The first
The defense to the second one was that they never had sexual intercourse.
Counsel, in your view, is it more prejudicial for a jury to know that this young man had a juvenile delinquency adjudication as a youth, or to know the specifics of the underlying commission of a violent crime?
I think you could say either, because if the jury hears this guy's an adult and he was adjudicated a juvenile delinquent, you know, a juror might naturally infer, oh, well, this guy's been misbehaving for years. That's where it comes from. The jury might draw an inference of criminal propensity.
But under our Molyneux jurisprudence, we allow the underlying facts to come in, don't we?
If, you know, assuming that it's otherwise proper.
Yes, I understand, the
Yes.
balancing, so it's not just, I
But here's
was
what the
just trying to
jury
follow
heard.
up on the Chief Judge's question. Generally speaking, wouldn't it arguably be more prejudicial to find out about what he did as a juvenile than the fact that, okay, well, he was, he was adjudicated?
Not in this instance. What did he do? He stole a bicycle from another kid. Now, back in my day, you didn't get hauled into court for that. The parents discussed it, and the bicycle was returned. But now everything's...
Was there evidence of other bad acts that the court allowed or said could be elicited if he testified?
I believe so.
So doesn't the theft of the bike, let's assume you're correct about the way you've characterized the theft of the bike, isn't that pale in comparison to the other bad acts?
Not necessarily.
Really, I mean, include a sexual assault, for example?
I'm
Of a
sorry?
One of the ones that was allowed was a sexual assault of a high school student? In
Well-
your day, how did that compare to stealing a bike?
Well, obviously, if it was sexual assault, if that were allowed in, obviously that would be very prejudicial. But I don't believe that occurred. If that had, I think I would have argued
Yes, let me
that-
ask you this. What rule are you asking us for? Are you?
That wasn't harmless.
No, let me finish. Let me just get the point out here. Are you saying that a Sandoval error, when defendant refuses to testify, then there's a Sandoval error, that it can never be harmless, and that you get an automatic reversal?
Oh, no, I didn't make that argument.
No, I'm asking you, what rule are you? Because that argument was made in Grant, and I want to know if that's what you're asking for.
Oh, no, absolutely
you
not.
asking
This is
for?
fact specific. I'm asking you that on this record,
Mm-hmm.
you find that it wasn't harmless.
I see.
I'm not asking you, I know what the law is, that this is a trial error that's amenable to harmless error analysis. I'm simply asking you to reject the ritualistic assertion that the evidence of guilt was overwhelming. And, you know, Frank, I've done over 100 appeals from criminal trial verdicts, and I have never once read in a prosecutor's brief a concession that evidence of guilt was not overwhelming. So,
Thank you, sir. Thank you, counsel.
okay.
Thank you.
Counsel?
Thank you, Your Honor. May it please the court, Peter Willis for the Schenectady DA's office. In this case, I think it's clear the judge's error was not preserved. There was no objection after the Sandoval compromise was issued.
You'd be slicing it awful thin, though, on preservation. You know, the counsel has a good point. You know, if you stand up and say, I think this is wrong, it's a juvenile delinquency judge, and the judge makes the wrong ruling, that, the way I read the transcript, the prosecutor knew it was a wrong ruling right then there and tried to point the judge in the right direction. He didn't take it. And the judge made an error, and we went forward. You're saying he has to repeat it afterwards, in essence, after he's made his objection. That could be a rule that we would come to really regret on a number of other cases, it seems to me.
Well, I think that when there is a compromise, when the prosecution says, here are all the facts, and we'd like this, and the court kind of, you know, splits the difference and gives part of it, if the defense still is objecting to that compromise, they have to put it on the record that they think it's wrong. And in this
Let's say
instance,
it was preserved, though. All right, was there any kind of minimal proffer made at all by the defendant to say that that would have protected their position?
from the defendant,
Yeah.
I think if defense counsel had said, Judge, with all due respect, juvenile delinquency adjudications cannot be used for impeachment purposes, so I would object to the use of the bare bones allegations, the bare bone request to cross-examine the defendant just on the adjudication. I think that would have sufficiently preserved the error. It also, when that happens, two things. One, the prosecutor is alerted to the fact that defense counsel does not want this ruling, and knowing its error, has the chance to say, Judge, we're not going to do that. We're not going to use a JD adjudication against the defendant in this case. Now, the proffer that the prosecutor filed in this case specifically said, we do not intend to use the adjudication. We intend only to ask about the underlying facts. That was on, I think it's the Respondent's Appendix, page 7. That's specifically laid out there. So when the argument is going on, when the defense counsel stands up and objects to the use of the facts underlying the robbery adjudication, the prosecutor's not thinking that he's objecting to the adjudication itself, because she's never even asked to use that. So once the judge comes out with this erroneous ruling, it's on the defendant to object to it.
So if we were to find that it is preserved, and then you concede that it was error, given the quintessential he said, she said nature of these charges, why wouldn't it be, how can it be harmless?
I think it's harmless I think it's harmless because in this instance, there was nothing that the defendant suggested, either through his defense counsel or even in the brief, that he would have offered to support his defense, other than some allegation that it was consensual. There's no...
Well, but that's pretty significant. That's his defense, essentially. And who else could possibly offer that evidence but himself?
Well, obviously the evidence could have been offered or could have been corroborated by the other points that are pointed to by defense counsel. Now,
Isn't there a difference? The jury is observing the two victims who say this happened to them, right? They're assessing their credibility, believing them or not, and he is not getting up and giving, if you will, his side, his version, so that they can assess not only him, but the women's version, hearing both of these renditions of these events?
I agree that in some circumstances you can make the argument that a defendant's credibility in and of itself is a determination that the court or that the jury is entitled to hear, but I think the decision in Grant specifically says that just the defendant's allegation that this didn't happen the way they said is not enough when the evidence is overwhelming to show that
Grant is a little bit different of a case, given the charges there. I think what
we're struggling with a bit is how do you apply harmless error in these circumstances when we've said you can consider whether or not the defendant would testify? What I think is different about this case, and I think Judge Wilson was getting at it earlier, is there were rulings in the Molyneux hearing about certain things that could be asked, right, prior to
I agree. Sandoval hearing.
Sandoval, I'm sorry, excuse me. Sandoval hearing. And so when we factor in, yes, we assume he would have testified, how do we factor in the harmless error analysis the fact that had he testified, he would have been asked about those things that were permitted in the Sandoval hearing? So it shouldn't be, it seems to me, that in that analysis, you get to assume testimony without the negative of what you would have been crossed on pursuant to the Sandoval ruling. And as I understood it, although maybe there's some dispute, there were Sandoval rulings that would have allowed cross-examination.
There was a significant amount of Sandoval material that was allowed in, legitimately so, and not challenged on appeal, including a felony conviction for drug possession in addition to several misdemeanors and endangering the welfare of a child adjudication that Judge Wilson, I think, referred to. So there was a tremendous amount of material. And when you look at the context of the harmless error analysis, I do not believe that it is improper to consider whether it is this one single instance of an improper ruling that dissuaded the defendant from testifying versus these 7 others. Say this was,
No, the point is we assume he's going to testify. And the point is whether or not he has critical information. So if his critical information is his articulation of his innocence, that's something for the jury to weigh. And they may very well not believe him based on some of these Molyneux rulings. But the point is whether or not under Grant's standard he has critical information to provide. The jury could discount it. The jury could not believe it. But the point is there critical information? I'm not clear on how his, the core of his defense, which is I did not do these things, and where the evidence doesn't necessarily show that he did these things, right? You have really their word. You have to believe their word.
I agree. That the credibility of the victims in this case is obviously paramount to the jury's decision. But there's not, it's not a fact, or it's not an instance where there's uncorroborating evidence. If you look at the first assault, she comes running out of the hotel room claiming he's raped, and the defendant is seen running away, leaving his
The
underwear.
defendant is seen leaving, and he admits that they had sex. The woman ran out, as he believes it's consensual. Well, we don't have to go into all the evidence, but this is my point. Is he not going to add critical information for the jury to consider? Because that's the standard when he gets up and gives his version of these events and perhaps better explains exactly what you're describing as showing that he is indeed guilty.
I agree that there is the potential for that, but I think in this case, the fact that he would have been cross-examined on not only the Sandoval instances, but the other allegations, the other evidence in the case, why did you call her friend and offer her $1,000 to keep her mouth shut before you even knew she was accusing you of raping her? Why did you leave your underwear behind in the motel
But you're
room?
sort of asking us to assume that his testimony is less credible. You're sort of asking us to be a fact finder.
Well, I think when we're making the allegation, and or not the allegation, the assertion, and I think backed up by the trial record here that the evidence is overwhelming, that is something that's naturally going to flow to the court in any instance. However, I think in this case, one of the other issues to consider on preservation is,
Well, they acquitted him of the drug counts, right?
Yes.
So they didn't fully believe C.W., of the first victim.
whether that he
She
had
said,
brought those there.
she said he threw the bag of drugs, he told me to take the drugs, and I guess they didn't believe that part.
Well, they didn't believe, I don't think there's any way to break down what they believe from her testimony versus why they acquitted him of those drugs, but that's,
Would you agree
Counsel,
with
in
that?
applying a harmless error analysis here, can we parse the analysis to victim A's case and victim B's case?
absolutely, Your Honor, and I think whether or not that occurs with the first count, which obviously as a predatory sexual assault encompasses the attacks on both women in combination, or if you just look at the criminal sexual assault conviction under count 2, if the court finds that there's overwhelming evidence with regard to one of the assaults and not with regard to the other, I think that there's no issue with sustaining a conviction on one and sending the case back for a retrial on the others. In this case, what I do think, though, The
But
ultimate
let me,
issue.
I'm sorry, is that really the standard? Because I'm a little unclear as to whether or not the appellate department applied the correct standard. Isn't Grant's standard whether or not the jury's been deprived of critical information?
If they've been deprived of critical information,
Not only determining whether or not the evidence is overwhelming based on what is presented, but this analysis, whether or not there's critical information that this defendant would have added when he got up and testified.
well, Your Honor, I think the basic problem with that type of approach is the defendant never puts anything on the record that indicates he has critical information on his defense,
That's
unlike
why
in
I was
Grant.
asking you before, when you go back to the last prong of the Grant test, there has to be the defendant's got to make some minimal proffer that would allow us to conclude at this point that there's a significant probability that his testimony would have led to an acquittal. So that's, it seems, what Grant is asking us to do if we're past the preservation issue.
Because even in Grant, the defendant, as the court will note, said on the record, I am my only source of the defense, and the court still felt that even if he's his only source of his defense, that he had, which would indicate to me that he has something critical to add, that doesn't occur. I mean,
Right, so his determination not to testify in and of himself does not translate into an automatic reversal, but maybe something less like defense counsel's asking for, or a sustaining of the conviction.
I agree, Your Honor.
Yeah.
Thank you, counsel.
Thank you.
Mr. Kessler?
First of all, on the issue of preservation, I think we're spinning our wheels because that wasn't an argument that people made in the appellate division. The appellate division reached the merits without discussing preservation. So I don't think this court can even find at this point that the issue's unpreserved.
Counsel, are you going to address the Antomarchi issue?
I'm sorry?
The Antomarchi issue?
Antomar, well, unfortunately, because of the time limits, I didn't get to address that. But
Care to do that now?
if you'd like me to, I would love to. But
Please do.
Thank you. I think that what the advice my client received was too ambiguous to secure a valid Antomarchi waiver. The court spoke about legal discussions at sidebar. The written waiver said discussions with prospective jurors and/or discussions of points of law.
What's ambiguous about that?
I'm sorry?
What is ambiguous about that? Assuming that the court not referring to the juror issue and only talking about legal issues, assuming that that's not good enough, what is ambiguous about the written waiver?
What's ambiguous about it, it doesn't really apprise the defendant. First of all, it refers to sidebar discussion with prospective jurors generically. Now, we all know if it's simply a question of, I'm going on vacation next week, so I can't serve, the defendant doesn't have a right to be present for that. That's just a ministerial kind of inquiry. But if it has to do with the qualifications of the juror, then the defendant has a right to be present. Nothing in the written waiver made any distinction between the various types of inquiries of prospective
The
jurors.
record indicates a couple of different conversations between the defendant and his counsel during this whole Antomarchi discussion, right?
Off-record
Off the
conversation.
record, absolutely. Can we infer anything from that?
No.
And from counsel's statement that I think he understands?
Well, he understands what? He didn't specify what he thought the client understood. I don't think you can infer from a silent record that defense counsel said to him, you have a right to be present for sidebar questioning prospective jurors on
So in
matters
your
of potential
view,
bias.
either the record of a colloquy or the written waiver has to go into how much detail is necessary to make it a valid waiver?
Well, I think you have to have something on the record that's alerting the defendant to the fact that he has a right to be present for sidebar voir dire on matters of potential bias or hostility. And there is absolutely nothing in the record here that my client
The
received.
judge tell him at any time if you have any concerns or any issues that you could ask the judge? So if during this proceeding he wanted to come up, couldn't he have said, I thought I couldn't come up, but could I come up now?
No, the judge said, if at any point, if we're discussing anything particularly important, quote unquote, then you can come up. I mean, that even makes it more ambiguous.
Thank you, Mr. Kessler.
Thank you.